A year after a constitution bench of 9 judges declared privacy a fundamental right, its fears of the emergence of the surveillance state have come true. Our government was successful in compelling BlackBerry to give to it the ability to intercept data sent over BlackBerry devices. While such interceptions may be desirable and permissible, in order to ensure national security, it can not be unregulated. George Orwell created a fictional state in 1984. Today, it can be a reality. The technological development today can enable not only the state but also big corporations and the private entities to be the big brother. Justice Sanjay Kishan Kaul and Justice K. S. Puttaswamy, retired, versus Union of India, and a unanimous judgment declaring the right to privacy as a fundamental right delivered by the nine-judge Constitution bench on August 24, 2017. On December 20, 2018, by issuing a terse statutory order SO 6227E, the Union Home Secretary Rajiv Gauba vindicated Justice Kaul's apprehension in the landmark judgment on privacy. Unmindful of the order's clearing inconsistency with the Supreme Court's pronouncement declaring the right to privacy an intrinsic part of right to life and personal liberty under Article 21 and as a part of the freedoms guaranteed by Part 3 of the Constitution. The order drew its sustenance from the subsections of Section 69 of the Information Technology IT Act 2000. Read with the Rule 4 of the Information Technology Procedures and the Safeguards for Interceptions, Monitoring and Decryption of Information Rules 2009. The order issued by the competent authority authorized 10 security and the intelligence agency to intercept, monitor and decrypt any information generated, transmitted, received or stored in any computer source under the Act. The agencies are the Intelligence Bureau, Narcotics Control Bureau (NCB), the Enforcement Directorate (ED), the Central Board of Direct Taxes (CBDT), the Director of Revenue Intelligence (DRI), the Central Bureau of Investigation (CBI), the National Investigation Agency (NIA), the Cabinet Secretariat Research and Analysis Wing (RAW), the Directorate of a Signal Intelligence or DSI for the service area of Jammu and Kashmir, Northeast and Assam only, and the Commissioner of Police Delhi. The authorizations granted to these 10 organizations has astounded observers and dismayed civil society. The word any before the word computer resource in the order sounded like every. Although the Supreme Court is in a recent case held that any does not mean every, the implication caused by a deep distrust of the state was ominous. The very mention of these 10 agencies in one order suggested that they had been handicapped by the problem of accessing information stored in any computer resource to perform their duties effectively. The order gave no reasons as to why only these 10 agencies were authorized, leaving one to speculate whether other agencies already had that power and therefore required no authorizations, or whether they did not require this power as per the center's reasoning. The term computer resource, as defined by Section 2K of the IT Act, also points to the possibility of the order being overbroad and therefore amenable to misuse by the authorities. Originally, it meant computer system, computer network, data, computer database, or software. In 2008, the Act was amended in such a way that the term included any communication device, such as mobile phones, within the definition. The official justification. Faced with civil society's outrage against the order, the Home Ministry sought to clarify the rationale of order through a press release, which read no new powers have been conferred to any of the security of or law enforcement agency by the SO dated 2012-2018. It has been issued in accordance with the rules framed in the 2009 and the BOG since then. Each case of interceptions monitoring decryption is to be approved by the competent authority, that is, Union Home Secretary. These powers are also available to the competent authority in the state government as per Act. IT Procedures and the Safeguards for Interceptions Monitoring and Decryption of Information Rule 2009. According to the subsection 1 of the section 69 of the Act as amended in the 2008, where the central government or the state government is satisfied that it is necessary or expedient to do so in the interest of the sovereignty or integrity of India for the defense of India. 4. Ensuring the security of a state and the friendly relations with the foreign states, or in the interest of the public order, or to prevent incitement to the commission of any cognizable offense relating to the above, or for the investigation of any offense, it may subject to the provisions of subsections 2 for the region to be recorded in writing, direct any of its agencies to intercept, monitor, or decrypt any information transmitted, received, or stored through any computer resource. Subsection 2 of the section 69 says that the procedures and the safeguards subjects to which such interception or monitoring or decryptions may be carried out shall be such as may be prescribed. The procedure and the safeguards and envisaged under this subsection, it appears, have not been sufficiently prescribed. The only safeguards envisaged under Rule 22 of IT Rules 2009, it that all such cases are to be placed before a review committee headed by the cabinet secretary, which shall meet to at least once in the 2 months of the review. Such cases, in cases of the state government, a committee headed by the chief secretary concerned will carry out the review. The Home Ministry's press note claimed that the SO would help in these ways. Firstly, it would ensure that any interceptions, monitoring, and decryption of any information through any computer resources done as per the due process of law. The note seemed to be a tacit admission that until now agencies had engaged in these acts without complying with the due process of law. Second, the order aims to prevent any unauthorized use of these powers by any agency, individual, or intermediary. This could suggest that there have been instances of such unauthorized use of these powers by an agency, individual, or intermediary, which led the government to proactively issue such as notification without receiving any complaint from an agreed party. As state surveillance takes place without the knowledge of the persons being watched, the question of receiving a complaint about any unauthorized use of these powers does not arise. Rather than investigate and bring to book those guilty of such unauthorized exercise of these powers, the order appears to provide an ex post facto justification for them and guarantee them legal protection from the prosecution. Third, the order would ensure that the provisions of law relating to lawful interception of the monitoring of computer resources are followed, and if any interception, monitoring, or description is required for the purpose specified in the section 69 of IT Act, the same is done as the due process of law and with the approval of competent authority, that is Union Home Secretary. It is clear that in the absence of the order, the government was finding it impossible to ensure compliance with the law relating to interception or monitoring of computer resource, and the other and that the activity was being resorted to without the due process of law or the approval of the competent authority. Significance of safeguard. The order states interceptions, monitoring, and decryption as its purposes. This implies that intelligence gathered by these agencies may be used for any purpose whatsoever, so long as it satisfies the meaning of monitoring. It is here that safeguard assumes significance. Effective safeguard can only be guaranteed by an exclusive data protection law, which the center has yet to enact, despite a draft bill having recommended by an expert committee headed by the former Supreme Court Judge Justice B.N. Sri Krishna. Collecting data beyond the requisite amount or purpose specified and profiling of individual or groups on the basis of such interception are the risk awaiting the country in the absence of an data protection law. The question remains whether the government will be the judge in its own case in deciding the extent and the scope of the monitoring data, as the existing safeguards do not provide a system of check and balance. The absence of effective safeguards against the misuse of these powers will likely make the Act's provisions more draconian than any may assume. Subsection 3 of the Section 69 requires the subscriber or intermediary or any person in the charge of the computer resource to extend all facilities and technical assistance to the agency. 2a. Provide access to or ensure access to the computer resource generating, transmitting, receiving, or storing such information. B. Intercept, monitor, or decrypt the information as the case may be, or provide information stored in the computer resource. Subsections enables the authority to punish the subscriber and intermediary or any persons who fails to access the agency referred to the subsection 3 with the imprisonment up to 7 years or and a fine. Experience with the Telegraph Act. The roots of the government's effort to snoop on digital content can be traced to the Section 5(2) of the Indian Telegraph Act 1885, whose constitutionality was tested by the Supreme Court and the People's Union for Civil Liberties (PUCL) versus Union of India in 1996. In this case, a bench of two Supreme Court judges dealt with the telephone tapping. The petitioner challenged the constitutional validity of Section 5(2) of the Telegraph Act and urged that the procedural safeguards against the arbitrary act of the telephone tapping be adopted. Section 5(2) authorizes the interception of messages in the transmission in the following terms. So, on the occurrence of any public emergency or in the interest of the public safety, the central government or a state government or any official especially authorized in this behalf of the central government or a state government may, if satisfied that it is necessary or expedient, then so to do in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, or public order, or for preventing incitement to the commission of an offense for reasons to be recorded in writing by order direct that any message or class of message to or from any person or class of person or relating to any particular subject brought for transmission by or transmitted or received by any telegraph shall not be transmitted or shall be intercepted or detained or shall be disclosed to the government making the order or an officer thereof mentioned in the order. A proviso to this section reads that press messages intended to be the published in the India of correspondent accredited by the central government or state government shall not be intercepted or detained unless their transmission has been prohibited under the subsection. The PUCL had approached the Supreme Court and the wake of the report on the tapping of the politicians' phones by the CBI, which was published in the General Ministry. Investigation revealed serious lapse on the part of the Mahanagar Telephone Nigam Limited (MTNL). The Supreme Court found in this case that the files pertaining to interception were not maintained properly. The Supreme Court held in this case that the telephone conversations were constituted to be an important ingredient of privacy and the tapping of such conversation would infringe upon Article 21 unless permitted by the procedure established by law. The court ruled that it would be necessary to lay down procedural safeguard for the protection of the right to privacy of a person until Parliament intervened by framing rules under Section 7 of the Telegraph Act. The court accordingly framed guidelines to be adopted in all cases involving telephone tapping. The Supreme Court's guidelines in the PUCL case were formally incorporated in the telegraph rules with the insertion of the Rule 419A, but the new rules could not offer effective remedies against telephone tapping in the absence of the independent oversight of the interceptions and the parliamentary supervision or control over agencies entrusted with snooping. Radio tapes. In 2011, in the wake of the Nira radio tapes, the center, through a press note, referred to the Supreme Court's ruling in the PUCL case on December 18, 1996, which held that the Section 5(2) of the Act envisages occurrence of any public emergency or interest of the public safety, which is a sine qua non for the application of this provisions. Neither of these are creative conditions or situations. Either of the situation would be apparent to a reasonable person. The center observed in the note on April 25, 2011. According to the note, public emergency means the prevailing of the sudden condition of a state of affairs affecting the people at large that calls for immediate action. It is it is one which raises problems concerning the interest of public safety, the sovereignty and integrity of India, the security of a state-friendly relation with the sovereign states or public orders, or the prevention of incitement to the commission of an offence. Public safety means the state of freedom from danger or risk of the people at large. When either of these two conditions are not in existence, the authorities cannot resort to the telephone tapping, even though there is satisfaction that it is necessary or expedient to do so in the interest of the sovereignty and integrity of India, security of a state, friendly relations with the sovereign state, public orders, or for preventing incitement to the commission of an offence. Contrast this with the December 20 order issued by the Home Ministry, which is silent on both public emergency and the public safety, nor does it cite any of the grounds mentioned in the section 69(1) of IT Act. In 2011, Cabinet Secretary, in response to a directive from the Prime Minister, recommended that the government either remove the Central Board of Direct Taxes (CBDT) from the list of agencies authorized to intercept telephone calls, since income tax laws fall within civil jurisdiction and do not always impinge on public safety or delineate the stipulations for and the extent of surveillance the agency is allowed, including the level at which requests were to be made for authorization by the Home Secretary. The Central clarified in a press note that law did not permit use of telephone tapping and monitoring of conversations to merely detect tax evasion. There are specific laws and rules that contains provisions for detection of unaccounted wealth and invasion of taxes and interception of telephone calls without public emergency or public safety being at stake was not in accordance with the law as exhaustively interpreted by the Supreme Court. The note said the inclusion of the CBDT among the 10 agencies authorized to snoop on digital data in the December 20 order exposes the lie being perpetrated by the current regime. The Justice B.N. Sri Krishna Committee report on the data protection, a free and fair digital economy, protecting in privacy, empowering Indians, submitted to the Central recently observes that there is no general law in India today that authorizes non-consensual access to person data or interception of personal communication for the purpose of intelligence gathering or national security. If there are any entities that are carrying out activities of such a nature without statutory authorization, for example, slowly through executive authorizations, such activities will be illegal as per the Puttaswamy judgment. They would not be operating under law. The Intelligence Services Power and Regulation Bill 2011 was introduced to regulate the functioning of Indian intelligence agencies and institute an oversight mechanism. However, the bill lapsed in 2011 and legislative vacuum remains. The Sri Krishna Committee report took note to the existing legal frameworks in the form of Section 5 of the Telegraph Act and Section 69 of and 69B of the IT Act. For each of these mechanisms, the report said oversight was carried out through a review committee set up under the Telegraph rules. This committee review interceptions orders passed under the Telegraph Act and Section 69B of IT Act. It consists of the Cabinet Secretary, Secretary of the Government of India in charge of legal affairs, and the Secretary to the Government of India in charge of the Department of the Telecommunication. As per recent right to the information application RTI application to the Home Ministry, 7,500 to 9,000 such orders are passed by the center every month. The review committee, which meets once in the 2 month, has a unrealistic task of reviewing 50,000 to 80,000 interceptions order in every meeting. The report said. Comments in the response to the white paper submitted by the Kalyan Vishwas Associate Vice President at Internet and Mobile Association of India on January 31, 2018 are available on the file with the committee. Additionally, the committee noted that the surveillance practices were also enabled by the license agreement entered into by telecom service providers with the government. For example, such agreements can mandate law encryption standard. These poses a threat to the safety and security of the personal data principal, the person, company, or entity whose information is being collected. More importantly, Sri Krishna committee observed surveillance should not be carried out without a degree of transparency that can be passed the muster of the Puttaswamy test of necessity, proportionality, and due process. This can take various forms, including information provided to the public, legislative oversight, executive and administrative oversight, and judicial oversight. This would ensure scrutiny over the working of the such agencies and infuse public accountability. The committee proposed that the surveillance architecture embed a systematic risk management techniques within itself. This would lead to the prioritizations or narrowing of its activities by devoting resources to credible risk, whether they're reputational or organizational. For example, an assessment of whether a particular measure was the least intrusive to achieve a stated aim may be required. This will not only reduce the costs incurred by the state but will be consistent with the civil rights protection. We hasn't that this recommendation, albeit not directly made a part of the data protection statute, and is important for the data protection principle of the implemented effectively and must be urgently considered. The committee said in its report. It said that the data protection law should require the enforcement agencies to ensure that the processing of personal data was actually necessary and proportionate to their purpose. For example, the maintenance of the DNA database of all citizens, some of whom may be innocent, to track crime without legal sanction would be a disproportionate law enforcement measure. A similar exercise was undertaken in the United Kingdom, where the government later had to delete the records of the more than a million innocent adults and children after the enactment of the Protection of Freedom Act 2012, with inter alia regulates the collection, retention, destruction of biometric data, surveillance and mechanism. Section 42 first of the Personal Data Protection Bill 2018 proposed by the committee states that the processing of personal data in the interest of the security of the state shall not be permitted unless it is authorized pursuant to a law and is in accordance with the procedure established by such law made by parliament and as necessary for and proportionate to such interests being achieved. National security. Courts have traditionally deferred to executives' prerogative on national security grounds. The moot question is how much actual security such a measures would provide. Scholars such as Jennifer Chandler argues that the highlighted surveillance often leads to less rather than more security since these measures have been known to disproportionately affect racial and religious minorities on the basis of profiling along those lines. These measures also seem to increase the feeling of security but do not translate into an actual increase in the physical safety. This condition is called security theater, where the mental aspect of the feeling secure is given greater importance than actual physical safety. If the national security is the objective, it is unclear why organizations aiming to detect financial and narcotics related offenses have been empowered. The NCB and CBDT pursue objectives under the national security. Justice Cole dealt with the profiling in his concurring judgment in the Puttaswamy case, right to privacy. He referred to the European Union regulation of 2016 on data privacy, which defines profiling eh, as any form of automated processing of personal data consisting of the use of personal data of to evaluate certain personal aspects relating to a natural person, and particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movement. Such profiling, justice call said, that could result in the discrimination based on the religion, ethnicity, caste. However, he added profiling could be used to further public interest and for the benefit of the national security. The security environment, not only in India but throughout the world, makes the safety of persons and the safety of matter to be balanced against the right to privacy, he observed. But then he warned, knowledge about a person gives a power over that person. The personal data collected is capable of affecting representation, influencing decision making processes, and the shaping behavior. It can be used as a tool to exercise control over us, like the Big Brother state exercise. This can have a stultifying effect on the expression of dissents and difference of opinion, which no democracy can afford. Even as the center seeks to acquire the power of surveillance in the name of the national security, it would do well to read what Justice Cole said in the Swami judgment on the right to privacy with the regard of the role of the privacy in preventing awkward social situations and the reducing social friction. The December 20 order faced the test of proportionality as laid down by the Supreme Court in the several cases.